You got hit by a commercial truck months ago, and now you're in pain, out of work, and wondering if it's too late to do anything about it. Maybe you didn't file the claim right away because you thought you'd heal, or maybe you weren't sure if it was even worth it. But wait too long and your entire case could get thrown out, regardless of how serious your injuries are. I'm Pablo Tamayo, a personal injury attorney here in Florida for almost 2 decades. And I'm going to break down exactly how long you have to bring a claim after a truck accident and what details most people don't even know exist. So you don't want to miss your shot at compensation just because the clock ran out before you took action. This question that might matter more than anything else: how long do I have to bring a claim? So here's the truth. It doesn't matter how badly you were hurt, how clear the fault is, or how sympathetic your story is. If you miss the legal deadline to file your claim, your case is over before it even begins. The court won't hear it, the insurance company won't pay you a dime, and your chance to recover what you've lost is forever gone. In most Florida injury cases, including truck accidents, you generally have 2 years from the day of the crash to file a lawsuit. Now, 2 years sounds like a long time, but it's really not. Not when you consider how long your injuries can take to heal, your treatment, how slow insurance companies move their claims, and how much evidence disappears in those first few weeks. The bottom line is, even if you've initiated a claim with the insurance company and have been in contact with them, if you wait 2 years to contact an attorney to represent you in court, it'll be too late. The claim will be dead, and there won't be anything that any attorney can do to help. That's what the statute of limitations does. It ends cases before they even start, even when you may be right. Truck companies are only required to keep critical evidence like driver logs, black box data, and dashcam footage for a certain period of time, sometimes as little as 6 months. If you don't start your case early and move to preserve that key evidence, that evidence can vanish forever. And once it's gone, it's gone. Witnesses forget details, photos get lost, the scene changes, insurance companies start spinning their version of events, and if you're not prepared, you'll get steamrolled. We've seen it happen many times. A client contacts us months or years after a truck crash, and by the time we get involved, key evidence has already been gone, has already been lost, and it makes the case more of an uphill battle than it needed to be. So, waiting doesn't help. It weakens your case, it gives the other side an advantage, and it makes everything harder than it needs to be. If you've been in a truck crash, here's what to do now, even if you're not sure whether you want to file a claim or not. Get medical care immediately, even if you just feel a little sore, even if you think you'll be fine. Injuries from truck crashes often show up later, and your medical records are the foundation of your case. Report the accident. Make sure the police create a report. Their documentation can carry a lot of weight later on. Gather evidence. Take photos of everything from the vehicles, the scene, your injuries, skid marks, weather conditions, license plates on the vehicles, if there's any signage nearby, anything. You never know what detail might matter later. Don't talk to the trucking company's insurance adjuster alone. They'll sound friendly, they'll act like they're just gathering information, but their job is to pay you as little as possible. Don't give a recorded statement, don't sign anything, don't try to handle it yourself, and don't wait to talk to a lawyer. Even if you're not ready to sue, even if you just want to know your options, a good Florida truck accident attorney can help you protect your rights, keep evidence from being destroyed, and stop you from making mistakes that can't be undone. Now, if your crash involved a government vehicle, like a school bus or a city garbage truck, different rules that apply. You may have 3 years to notify the government in writing about your claim, but you can't file a lawsuit until you've given them at least 6 months notice to respond. If it's a wrongful death case, that written notice must be sent within 2 years. These deadlines are strict, and the process is technical. Now, one misstep and your case could be thrown out. So if a government vehicle is involved, talk to an attorney immediately. The laws can be very tricky with government entities, and they're constantly changing year by year. Also, don't confuse the lawsuit deadline with the insurance claim deadline. They're not the same. Most insurance policies require you to notify your insurer within days of the crash or within a reasonable time. If you wait too long, you may have to fight for your own coverage in addition to the other person's coverage. If you have PIP benefits, the no-fault coverage in Florida, you must get medical attention within 14 days of the crash. 14 days. Strict. Miss that window and your PIP benefits won't pay a cent. Still not sure if you have a case? That's okay. You don't have to decide everything right now, but you do have to protect your options, and the only way to do that is by starting early. Ask questions, get answers, talk to someone who knows the system and can guide you through it. Because at the end of the day, this isn't just about paperwork or deadlines. It's about you getting the treatment that you need, the money you deserve, and the peace of mind that comes from knowing someone has your back. So don't wait. Protect your rights before the clock runs out. And if you want to make sure you're getting every dollar you're owed after a crash, and not just for your injuries, but for the lost value of your vehicle, watch my next video, Diminished Value Claim, Recovering Insurance Money After a Car Accident. Most people leave that money on the table. Don't be one of them. I'll see you over there.